Still fired.
All right, Ms. Kessler, I'm bringing you back because.
Because you like me. Thanks,
Well,
I'm flattered.
All right, Ms. Kessler, you've been disruptive and I've not been able to ask you any questions. So it's been hard for me to act on anything that you've requested of the court. So
Let's start back whenever we had Jordan Beard sit next to me and supposedly represent me. I gave him a chance and he shot it. And that was earlier this year, I think maybe February. And let's just replay that video and we can discuss that. And that'll answer all of your questions. You have a question, I'll just point to the video and say right there, right there.
well, we're not going back to the video, but ma'am, you said
No, you don't.
at this point in time,
Right.
are you asking for new counsel?
I've been asking for new counsel.
Okay,
I didn't
can
say
you-
anything whenever Jordan was sitting next to
Yes,
me because I'm not allowed to supposedly speak because I have someone sitting next to me. So I waited months and months and months and months, and I'm done waiting.
All right, so that is the basis for why you are asking for new counsel?
That's just the tip of the iceberg. Everything, the majority, I wouldn't say everything he said that day, but many of the things that he stated that day were absolutely false. They could easily be proved that they were false. And I'm not gonna use any adjectives to describe these people sitting here, but the one in the middle just shooting off her mouth saying, "Go Jordan, go!" And I'm like, oh my God, he's saying he's wrong. But I felt that if I said anything, it would be contempt of court, because that's what I learned at Florida State Hospital, you can't speak. So I'm like, well, maybe I'll get a chance to speak later, and I never got the chance, and now I'm talking.
Okay, so is there any other specific reason why you would like to have new counsel appointed?
I want to replay the video and we can go over that. Is
Yeah.
everything, I don't know, again, I don't want to say everything, but many of the things he stated were incorrect, and I had mainly the one in the middle, like shooting off her mouth saying, "Go Jordan, go," over stuff that is completely fictitious.
All right, counsel, do you know what she is referring to?
Nobody wants to bring up the video, like it's not on SoundCloud.
Counsel,
I'm sorry.
we can't hear a word you're saying.
I do not know, we do not know this is a reference. Other than Mr. Beard did represent her during one of the competency proceedings, so assuming it's.
No, I know Mr. Beard represented her a while back, but that ended, I guess, many months ago.
Right, it was many months ago.
All right, so is there any other reason why you believe that I should appoint new counsel for you?
That wasn't so much for a competency hearing as you had Dr. Danzer up there on the stand who was also advocating for me to have other counsel.
All right,
And he sat there, Jordan sat there of many things that he said I did drugs. I don't do drugs. He said I did crystal meth. I've never done that before in my life. He said that at Florida State Hospital, I refused to bathe and I refused to accept this Dove soap that's provided to everybody. No, the Dove soap is not provided to everybody. It's only provided to us once a day, and I received it happily every day. And sometimes I asked for more because they didn't give me quite enough that you could like wash from head to toe with it. So it's just like stupid. Some of it's like small lies that are, but it's ridiculous.
all right.
Trying to prove that I was incompetent. He was fighting against me, trying to say I was incompetent. Probably the most I've been represented was probably during that court date by the prosecution. Yeah, they did a great job. You know, like she seems confident to me. She made her car payment on time. She even paid with the head. Blah 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 blah. You know, that's probably the best I've ever been represented thus far has been by the prosecution.
All right.
Yeah.
Well, thank you, Ms. Kessler. I've heard what you've said. I do not find that those are adequate grounds in which to appoint new counsel for you. My counsel, from my perspective, has been effective. They've filed numerous motions and advocated on your behalf. Many of the things that you have stated here simply are not factually correct. And so I'm denying your request. All right, so we'll go forward with counsel here at the table, or you do have the right to represent yourself.
Oh yeah, back to that again. You want to put me through law school for 8 years and once I pass the bar exam? Sure, I'll be more than happy to do that.
Well, your counsel is there then, unless you want to represent yourself, all right? But we're going to proceed
Okay,
forward.
you're fired. All of you are fired. There you go.
All right,
And I'll
well-
just yell.
All right,
Jordan Beard is Jolene's cousin. Jordan Beard is Jolene's cousin, and you knew it too. Jordan, and I gave him a chance. My mom laughed in my face. She's like,
Ms.
why would
Kessler-
you have,
Ms.
you know
Kessler
that that's
has
his
now
cousin,
become
her cousin,
disruptive.
why would you even trust my mom?
Deputy,
Well,
you
maybe
can
he'll
pull
do
her
the job.
out. Thank you.
Jordan Beard is Jolene's cousin. 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 Jordan Beard.
All right. While they're taking Ms. Kessler back down to the holding cell, where she will again have video and audio to view the proceedings. I do want to state for the record that I was in the process of moving to a Ferretta inquiry when she said that counsel were fired. I was prohibited from doing that because she began screaming again and had to be removed from the courtroom. I believe based on that she has not been able to comport herself in a proper manner in court, or not willing to comport herself in a proper manner, that counsel will still continue to represent her. So at this point in time, we have a number of motions that we need to address, counsel.
Yes, Judge, we believe that the statements of Ms. Kessler clearly indicate her incompetence to proceed, and we raise that issue again. She is confused about who is representing her. She's confused about the job that counsel is doing. She believes the prosecution represents her, which is a completely inadequate understanding of the process of the judicial system. I believe that it's clear from her most recent statements in court that she does not have a competent understanding of the judicial system, the process, does not have the ability to in any way consult with counsel to adequately prepare for a defense in this case, which we believe we have a good defense in this case, but we cannot communicate with Ms. Kessler in that regard. As you can see, she is somewhat completely delusional about the facts, the previous facts of the case. I've never sat in the middle of the table, the chair in the middle of the table and said or screamed or yelled, "Go, Jordan, go," as Ms. Kessler recounts. Her understanding of what has happened here in court in the past and in the present clearly evidences her incompetence to proceed. And I think that at least 3 out of the 6 factors in the competency statute are evidenced by her behavior within the last 15 minutes here in court. And I would ask again that you find her incompetent to proceed and commit her for involuntary hospitalization and competency restoration.
Counsel, you wish to be heard? So this on defendant's Ortenis motion.
What I heard was the defendant say that she is not incompetent. She was unhappy with the public defender's office for presenting her as incompetent. She did not say she was represented by the prosecution, but that the prosecution did the better job in showing that she was competent. I do not believe that. In fact, her behavior, I thought in court this afternoon showed just how willful her disruptions are. She was able to talk and I don't want to say threatened, but used some coercive terms about what she wanted from the court. And when she wasn't going to get what she wanted, she said, "Okay, I'll start yelling again." And so I do not think that there's been any change in circumstances to necessitate a question about her competence.
All right, thank you, counsel, on both sides. I am denying the motion. I did not view her statements about the defendant's or the defense counsel's role in the state attorney's role at competency hearing as confusion, but that she is again asserting, as she always has asserted, that she is competent. And obviously there were questions that we sent her to Florida State Hospital. She was observed for 3 months, 3+ months on 24 hour, 7-day-a-week basis. This court has written again extensively after hearing evidence, the various hearings, finding her competent after she was returned from the Florida State Hospital. Nothing that happened in this exchange did anything to dissuade the court from that. It's not any different behavior. And in fact, demonstrates to the court that she understands exactly the role of the court, exactly the role of the prosecution, exactly the role of her attorneys. And I know that the big dispute has been whether what she does with her refusal to conduct herself accordingly in court and to consult with her attorneys is the product of mental illness versus being volitional. I have made a finding of fact several times on that issue, and I have seen nothing that would change this court's determination on that issue. And so the request is denied. So at this point, we do have a number of motions which we must take up that were filed at the 11th hour, although some of them I can certainly, it's not saying in a derogatory manner, it's just that there were some last minute things that I think the state properly brought to the court's attention and the defense properly brought to the court's attention. So I don't know which one you want to go to first. The defense motions filed a little earlier than the state's motions. So perhaps we'll do it that way.
I listed ours out, I have ours on the list of.
We have the 27th motion in limine.
Right.
You have the 28th motion in limine. We've heard the 29th motion in limine. You all are going to come back to that. There's a motion for rehearing on the state's first motion in limine dealing with evidence of drug usage. And then the motion to transfer venue has obviously been held in abeyance for proceedings and jury selection of that. That's what I have for the defense.
We had filed a notice of relying on two summaries. I don't know if the state had any objection to those of the FDLE reports of Amanda Stratton. There was
I can't hear you back here because it's fan.
Well, is the microphone working?
maybe
Well,
I'll speak into it.
maybe.
We had filed a notice of an intent to rely upon two summaries of the FDLE reports prepared by Amanda Stratton. We had the curative instruction. I think the state filed one of their own this afternoon after jury selection this morning. And there was a notice to take, request to take judicial notice of the Hillsborough County injunction case, but I believe that's also part of the state's, one of the state's recent motion in limine. Can I address our first motion in limine number 27?
You can.
We were going to ask the court to just hold that one in abeyance at this time and not rule upon it. We have an appointment to meet with Detective Harrington this afternoon at the jail to view some additional evidence that we think may, one way or the other, either cause us to withdraw that motion or perhaps make it stronger. If we could just hold off on that one.
All right.
Next would be defendant's 28th motion in limine regarding some statements that were made from Ms. Kessler to Detective Harrington. They're spelled out in the motion, referenced on page 18 of his report. I don't know if the state has any objection to that motion.
Well, I will hear from the state. Did they have an objection or not?
What they're requesting is that the defendant's statements be excluded, her statements being to the police that she was on the run from the FBI for 24 to 25 years and wanted on criminal charges in several other states. Because they're the defendant's statements, they are not inadmissible hearsay, as the defense argues. What we had planned on doing in an abundance of caution is just having Detective Harrington say that she was on the run from law enforcement, but and we weren't going to go into the FBI in 24, 25 years.
All right, so I assume that's an objection. So would you like to be heard?
Well, certainly, Judge. That has no relevance to the facts of this case. Clearly, there's nothing relevant about that. That clearly would be impermissible character evidence that she's on the run from law enforcement. And if it had any probative value, it's substantially outweighed by the danger that There's some other uncharged crime out there that the jury would consider.
Well, the statements are, if I recall, were made spontaneously on a telephone call, I believe? Or was it the first telephone call that Detective Harrington had, or was that at a later time?
These are from a later time.
Okay, well, she said, I was on the run for the FBI. Under what context were they made? Was that an interview at the jail or where? I don't have the motion in front of me.
He doesn't say, I know, I just wanted the defense counsel know. When she is transported by Detective Beasley back from St. Johns County, back to Nassau County, and she volunteers to Detective Beasley that she's been using an alias and her real name is Kimberly Kessler. She goes on to say that she's been on the run from the FBI for 24 or 25 years and was wanted for crimes in several states. She then reiterated that to Detective Harrington in the interview room when she was received at the Nassau County Sheriff's Office.
So the state has agreed that there's only going to be one alias used, or
We have.
information as
We
one
have.
alias, which is Jennifer Seibert. And so she makes these statements on the way back when she's being transported from St. Johns County. All right, and so tell me talk to me about what the state believes is the probative value of this evidence.
So the state's evidence will show that the defendant was, of course, using this false name at the salon, and that Joleen Cummings had conversations in her presence about her being fake, and that she was going to get to the bottom of who the defendant was.
Okay, well all that's well good, but how does the fact that she says that I've used aliases because I've been on the run from the FBI, which I'm not sure that that's even true. I don't know one way or the other, but why is that? I mean, why do you need to go beyond using false names? And Joleen Cummings had apparently made some statements that she found out about that.
Well, not that we have to prove motive, but as a motive, if the defendant is using an alias because she's on the run from law enforcement and has been, and Joleen Cummings is saying, I know you're fake, and telling their coworker, Ann Morgan, that she's going to get to the bottom of who the defendant is, that would be a motive by the defendant.
Okay, I can see where you're saying if the defendant confirms that she's using aliases, all right, then that would.
The victim?
I'm sorry. The defendant confirms that she's using aliases, and there's going to be evidence that the victim in this case accused her of being fake, and that might have some probative value, but going further and saying I'm using aliases on the run from the FBI. Why do we have to go that far?
There's no evidence that that's even true, by the way.
Well, and that's what I said before. I mean, I don't think anybody's dug up any evidence about
No evidence that is
that.
actually.
Why do we have to go to that final step and just say that evidence is that, she said, she confirmed, yeah, I've been using aliases.
Okay, well, where we've not confirmed that the FBI wanted her for the past 24 or 25 years. There was criminal activity in her past. And it's one thing to use a false name and not want anybody to find out that your name is really Kimberly Kessler instead of Jennifer Seibert, but it's another, the reason you're using a false name is because you are running from the police, or you believe you are wanted by the police.
It's very speculative. One of our other motions, or the notice that we're asking the state subjecting to, is that you take judicial notice of records from Hillsborough County that shows that Kimberly Kessler was the victim of a felony ag assault, domestic violence. The ex-boyfriend pled to that. There was an injunction that is currently in place through 2036. And so there are multiple reasons why someone would want to not necessarily let the world know who they are if they're trying to hide from someone else. So that's certainly an alternative that we are going to want to have a chance to offer as an explanation. So it's awfully speculative what the state's offering without sort of connecting that. She made these statements. We have no indication that it's true at all. There's no probative value, as the court's noted. It's
No,
clearly-
I didn't say there wasn't any probative value. I see probative value in the fact that she confirms that she's using aliases. It was just the second step.
Right, so why? And we have an alternative explanation for the why.
Okay, but if you bring in that alternative explanation, why can't state then bring in the counter to the alternative explanation?
And Your Honor, and I don't want to stray too.
No, I asked him a question, not you. Hold
Oh,
on, now, you know, I mean, if you bring that in, why can't the state then come in there and provide the defendant's own statements that contradict that very piece of evidence? And again, I'm not saying which evidence is right or wrong, that would ultimately then be a jury issue.
Right.
Would you agree with me?
I would if there were any truth to it. If there's,
Well,
again,
but
there's no
that's
truth
not
to it.
played. No, I mean, okay. Well, I'm pretty comfortable now that we've talked this out of where I want to be, okay? I think the fact that she confirms in these conversations, or the statements to the officer, to the detective, that's probative value. And the fact that she confirms she's been using a different name, all right? Because that's part of the state's theory of the motive in the case. All right, the second step of I've been using it to run from the FBI, I agree. If without more, that's probably the danger of unfair prejudice probably outweighs the probative value of that extra piece of information. Okay, but if the defense comes in here and I admit this evidence about the domestic violence, the injunction and the assault in the court file down in Hillsborough County, I think it opens the door to the state to be able to present and rebuttal her own statements that contradict that. That's where I'm at. I'll give you one last shot to tell me differently.
well, yes, sir. And I understand what you're saying about the fact that we show one thing, and that is that she admits she's using aliases. She used multiple aliases. We've agreed to use one. We're talking not about somebody who unfriends someone else on Facebook because you're threatening to out them for using a false name. You're talking about murder. And so she knows that she's accusing me of being fake, and I am running from the police. And so I commit murder. There is the end result is very, very serious, where it may not make sense if it's just because you're using a fake name, but you're using a fake name to avoid criminal responsibility from law enforcement. Makes it certainly a much more serious consequence to the defendant, and therefore would be certainly more understandable or relevant to end in murder than simply she thinks I'm using a fake name.
Except I think there would have to be some truth to it. There's no truth to it. There's no truth. That's not true. There's no evidence at all that this person was ever wanted by the FBI.
I left out the FBI. I have said from the beginning that we have talked to our detective and we have planned to limit it till she was on the run from law enforcement.
Okay. All right, counsel, in light of the state's last argument, from the standpoint of motive, I can see why there is having the additional piece of evidence on being on the run for law enforcement has more probative value than perhaps I gave it a little while ago, as far explaining why someone would commit an act of homicide, or as the state has alleged here. And that while there is some danger of prejudice, because there might be some, the inferences that there might be some uncharged crimes and things like that. I think with the state's limitation of just general law enforcement, not the FBI, I think the danger of unfair prejudice is outweighed by the probative value of the evidence. Now we've talked it through to the end. All right, so I'll just limit that to, the state can bring it in, but they just need to limit it to generically law enforcement and not the FBI. But otherwise it is denied. All right.
You're under the 20.
Certainly.
Judge, if we could address motion eliminate number 29.
Okay.
This was just the one that we'd asked the court to have the state not refer to Miss Cummings as a victim. They should refer to her as either Miss Cummings or missing person. There's any number of other, I think, more appropriate titles that would apply until a jury has heard the case and made a decision.
State, you wish to be heard on?
Yes, sir. The case law that the defense cites as the basis for their motion is when in a particular case where there was an allegation of self-defense and the question of whether a crime had even occurred. And so the request was that, or the alleged error was that, and consistently referring to the victim as a victim in that case, not just in closing, but throughout the trial, was improper because there had not been an established fact that a crime had occurred. That is different than this case where there is no allegation of self-defense and therefore a crime has occurred. The question is who did it?
Response?
We'll just rely on what's in the motion. I mean, clearly the issue here is very similar as to whether a crime had occurred. Something the jury.
Well,
has to
there's not,
consider.
I mean, I think that, well, I don't want to get into me saying whether there was or wasn't a crime, that a crime occurred, but there is video of the Ms. Cummings vehicle being driven late at night without Ms. Cummings driving it. So, but here's where I'm at. I'm denying the motion, but it's without prejudice to the defense to make objections if they believe that the state is trying to use that to, in an unfair manner during the trial. I think, one of the things that I think is certainly permissible from the state to say is, in opening, we believe the evidence is going to show that Joleen Cummings was a victim of a crime. And under your motion limited, they couldn't even do that. Which, I mean, that's clearly permissible or in closing argument. So we think the evidence has shown that she was a victim of a crime. This is what it shows. And so I'm going to deny it. And I'll be candid with you. I've never really had an issue in the cases I've tried up here with people trying to use that to sort of inflame the passions of the jury or anything like that. I'm not personally experienced that with any of the lawyers that are in this courtroom or really any of the ones I've tried and do all for many years. So, but if you feel like that they're using it in a manner which is set to try to inflame the passions of the jury and otherwise have them jump to a conclusion without any evidence to support it, then you certainly are free to object at that time. Okay.
Yes, sir, Judge. Do you want to address our motion for rehearing on state's first motion in limine next? Ms. Sopper.
I'm open to whichever way you guys want to go. All right. Now, let me pull the motion out. Just filed on November 22nd.
I had October 27th Oh, you mean our motion or the state's motion?
Your motion.
Our motion was filed on November 22nd.
All right, let's talk about it. Let me hear from the defense counsel.
The reason this motion was filed so late is because we discovered evidence that had not previously been revealed to us in discovery. And what that evidence was an FDLE analysis of a baggie of controlled substances taken out of Joleen Cummings' purse, which was recovered from Joleen Cummings' vehicle. And it was tested positive for methamphetamine. And at the time we argued the state's first motion in limine, we were not aware of the fact that this item had even been sent to Florida Department of Law Enforcement or that there had been any analysis of it. It was not included in any prior discovery for the last 3.5 years in this case. So when we discovered that, we were aware all along that there had been a confrontation between Kimberly Kessler and Joleen Cummings regarding Joleen Cummings bringing drugs into the Tangles hair salon. Kimberly Kessler and Joleen Cummings had both texted Vicki Simmons, the owner of the salon, about drugs that were found in the salon. And Vicki Simmons and Ann Morgan will both testify about that and will both testify that it was an ongoing issue and that Kimberly Kessler was very upset about it and did not want to work in a salon that had drugs and was very concerned about the drugs being blamed on her. She told Vicki Simmons, Ann Morgan, and Detective Douglas about finding one baggie of a tiny little Ziploc baggie with residue with crystals in it and confronting Simmons with it. And Simmons indicated she threw it in the trash and told both Joleen and Kimberly Kessler that. So we're able to establish by competent and substantial evidence that there was an ongoing dispute between Kessler and Cummings regarding the use of drugs at the salon. Now, when we argued the first motion in limine, the state had talked about the alleged drug usage of Joleen Cummings. But now we have absolute, concrete, substantial evidence in the form of a laboratory analysis previously unrevealed to us that Joleen Cummings' purse contained a baggie of methamphetamine. So that's why we're asking for a rehearing on this, because all of the evidence that precedes the period of time before the altercation in the salon on May 12th establishes that there was an ongoing confrontation or an ongoing tension between Cummings and Kessler about these drugs. And until we learned that, in fact, the drugs in Cummings' purse had been found to be actual methamphetamine, about which Kessler had been complaining for several weeks, we were not in a position to adequately argue against the state's first motion in
Let
limine.
me stop you real quickly.
Yes.
The evidence in this case about this ongoing concern, dispute about drugs at the salon, was that linked to Joleen Cummings or just in general a dispute or concern that was expressed by the defendant in general to the owner?
It was linked to Joleen Cummings. The defendant, Ms. Kessler, complained both to Ann Morgan and to Vicki Simmons that Joleen was bringing drugs into the salon, and she also complained to the worker at the barbecue, at Woody's barbecue restaurant at the end of the strip mall. She also complained to several clients, which angered both Ann Morgan and Vicki Simmons, that Kessler was telling clients that Joleen was bringing drugs into the salon. So yes, and in fact, the only people that worked in the salon at the time were Kessler, Cummings, Morgan, and Simmons, who wasn't really working there because of her health conditions. So it was really only the three stylists that were there at the time: Morgan, Kessler, Cummings.
Okay, so you want to have evidence of what was found in the purse in Ms. Cummings' vehicle.
Well, yes, we want you to reconsider the state's first motion in limine and deny that so that we can put all of this evidence in about the basis for the tension, the basis for the altercation, and the underlying truth behind those allegations to show that it was not just something
Well,
made
I
up.
know that maybe there's been so many motions and I've got to go back and read it, but the order, but I don't know that necessarily that the order prohibited the defense from raising the concerns that, or presenting the concerns that the defendant raised. It was just the actual potential drug usage on the person of Joleen Cummings. But anyways, let me hear from the state. What's going on? Why wasn't this discovered or turned over to the defense earlier? And what's going on?
Okay, so as to the state's first motion in limine, what we asked to exclude or prevent the defense from putting before the jury is any evidence regarding Joleen Cummings' character, including alleged drug usage, as well as reputation for violence or specific instances of violent conduct. So what we asked for and the court granted was Joleen Cummings' alleged drug usage. There was no mention of drugs in the salon or any of that. So the state's position is that, and the court granted the evidence related to the victim's alleged drug usage. So that's not what we're talking about. That's not what defense counsel is talking about. Although it's saying that they need a rehearing because now they can prove that the alleged drug usage was real drug usage. We asked to keep out any evidence of Joleen Cummings' character, and they have not presented. The fact that the drugs went to FDLE doesn't change any of the facts that the court relied on in granting the state's motion. Now I want to talk about what other things they have alleged in court today, as well as in their motion in limine. One, that the baggie was found in Joleen Cummings' purse. First of all, we're not talking about the same baggie that there had been, that the defendant allegedly found in, I shouldn't say allegedly, that the defendant, well, I will, that the defendant allegedly found in the salon and turned over to the owner, Ms. Simmons, who destroyed it. So we're not talking about the same baggie.
And that in the first motion in limine doesn't cover that. And
No,
that's
sir.
evidence that you can present.
Okay.
Okay.
I mean, that's what I was referring to, but y'all filed 30 of these motions, and sometimes it's hard to keep up with all the fine details. But anyways, go ahead.
Yes, sir. However, again, referring to their motion, that a baggie was found in Joleen Cummings' purse.
Right.
There was a baggie found. It was not Joleen Cummings' purse. Joleen Cummings' purse and wallet, those sort of things have never been located. There was a tote bag of papers and books and what have you that was recovered from Joleen's vehicle. As an aside, the last person we know to be in Joleen Cummings' vehicle was the defendant.
Whose purse was it?
It wasn't a purse. It was just a tote bag. It was Joleen Cummings' tote bag with Joleen Cummings' papers and what looked to be books, that sort of thing,
And
in
that
her
was
back
where
seat.
this bag that has been tested positive for methamphetamine was found.
Yes, sir.
So it's in a tote bag.
It's in a tote bag,
Okay.
not a purse.
With-
From the vehicle that the defendant had exited, that belonged to Joleen Cummings. Defense counsel was aware of the baggie. They were aware that it had been field tested positive for methamphetamine from the beginning of this case. We did not know that it had gone to FDLE. When defense counsel went over and looked at the evidence, they saw an FDLE sticker on it. They asked us and we pulled the report. So for them in number 3, that the state intentionally and willfully failed to provide the results of the 2019 FDLE testing. It was not intentional or willful. We didn't know it went to the FDLE. Obviously, law enforcement had sent it over there. And as soon as defense counsel saw the sticker, we pulled the report. Now, and we can either do it now because we're kind of in the middle of it, but I've also filed a motion in limine about the drugs. So what we have is defense counsel, first Mr. Townsend in the last motion, and now Ms. Scott in this one, says we have a legitimate defense. And it's a known dispute or confrontation between the victim and the defendant. The problem with that is that the defendant doesn't say that. So what the defendant says is it was a normal day at the salon. Joleen Cummings was normal. There's no allegations from the defendant that anything occurred over these drugs other than she had found a bag of drugs, what she thought was drugs inside the salon, and turned it over to Vicki Simmons. So whether the drugs, whether a baggie was found in Joleen Cummings' tote bag in her vehicle that the defendant had stolen and gotten out of, and whether it field tested positive and or went to FDLE and tested positive is irrelevant to even the defense's position that there was a dispute between the victim and the defendant over a bag of drugs, alleged drugs that had been found in the salon and destroyed.
Judge, can I just add?
No, first of all, will you repeat what you just said? I get messages from people, the microphone's not working, your judge's microphone's not working. My microphone's working, okay? And I'm sorry. I want to hear what you said, and I'll give you a chance to rebut, okay? So go ahead, and if you'll repeat what you just said.
Yes, sir. So, and it was just the last thing that I said. So you got the part about that the defendant did not make any kind of claim about drugs at issue in this case. The defendant said it was a normal day and she doesn't know what happened to Joleen Cummings. All right, then the last thing that I said is that the defense, okay, so there's at least two baggies we're talking about. We're talking about the baggie that the defendant found in Tangles, or says she found in Tangles, turned over to Vicki Simmons and was destroyed. And then we have.
It was only the last statement. I've been following your argument.
Yes, sir.
I've been paying attention to it. It's just the last 20 seconds.
That whether there was a additional separate baggie of methamphetamine found in the victim's tote bag in her vehicle after being stolen by the defendant, it's irrelevant and does not go to prove anything about what was going on inside the salon, nor does the fact of whether it tested positive for methamphetamine or not.
All right, now let me hear your response.
I think what the state just said underlines the reason that we are putting this into evidence. The state says Kimberly Kessler didn't say anything about an ongoing tension between them. Well, she has. She constantly said that, according to the owner of the salon and the manager. But I want to clear up one thing. There are 3 bags of methamphetamine. There's one that was thrown away, one that was recovered from the salon by law enforcement, and one that was recovered from the purse, also known as tote bag in.
And stop right there. The second one is not linked necessarily with Joleen Cummings. It was just recovered in the salon.
That's correct.
But I'm sorry, it wasn't recovered in the salon. The detective doesn't know who found it or where, but the address associated with this baggie of unknown substance, the address associated is the salon address, but it is unknown where or by whom it was located.
So someone just found the baggie and didn't document where they found it?
It is in evidence, and the detective, once the defense counsel saw it, the detective is trying to figure out who found it. But
well, either way, it's not associated with Joleen Cummings.
It is not.
And it's not part of the motion, the first motion in limine. So the 2 baggies, we're not talking about, the motion in limine doesn't reach anything other than what was found in the purse or tote bag or whatever it is called in the vehicle. The motion in limine doesn't affect the other 2 items. So I mean that's the way I read the motion in limine, and I think that's the way the state sees it. And so I don't think you got to worry about even having a rehearing on those 2 items. So let's talk about the tote bag. All right.
I believe that the evidence establishes clearly that it is Joleen Cummings' tote bag. It's right in line with what Kimberly Kessler had been complaining about to the management, to the owner and to the customers for several weeks. It is right in line with Joleen getting angry with Kessler and saying, you're a phony, you're a fake, I know who you are, I'm gonna find out who you are, I know you're not who you say you are. It's right in line with the fact that these two women were moving friction every day, more and more friction. They were moving into an antagonistic relationship. And we believe that it goes to prove the fact that our client who was complaining about the drug use, it underscores that particular factual or that particular piece of evidence. That it shows that our client was not making this up when she was talking to Ann Morgan or to Vicki
And there
Simmons.
will be testimony from the, I guess, I don't know, Miss Morgan or whoever it is, that are text messages or emails that specifically charges that drug usage in the salon is linked to Joleen Cummings, not just in general.
Yes, Judge, I have those here. If you'd like to see them, I have the text
You agree
messages.
with that?
I do not, but we can go through the text messages that.
Let's please, one side says it's blue and one side says it's white, and it's gotta be something, what's one or the other. Can you tell me what they say? I mean, it makes a difference, it does, as to what your client was alleging. I mean, drug usage, if there's other people that are bringing it in, or if it's related to Joleen Cummings as alleged by your client.
I am looking at a text message from my client's cell phone provided to us from the state, dated March 27th, 2018, which says, hello, Vicki. Found a tiny Ziploc baggie with question mark drugs, question mark, residue in it. Want me to, the number 2, give it to the number 2, Philex, Philex, question mark. And then there's a response to that text, ostensibly from Vicki, but the response says what, question mark, question mark. And then there are 2 periods, and then it says where, question mark. And then there's no response regarding that. Those are the 2, that's 2 text messages. And then also Vicki Simmons admitted in deposition that she had been texting Kimberly Kessler regarding the
I'm sorry, what did you just say?
in the deposition of Vicki Simmons, which was taken on February 25th, 2019, she was asked, and did you ever receive any complaint from Jennifer Seibert about a baggie of drugs found in the salon? Answer, she did tell me that she came in and she found it. And Joleen told me when I asked her about it, she said, there is no way that she could have been there because I swept the floor last night, so. Question, when did that happen? Answer, oh gosh, it wasn't too long after she started. And then they go on. And then the next question regarding the drugs is, okay, she just told you that she had found this. Answer, yes. Question, all right, and did Ann, and Ann is A-N-H, actually, Ann Morgan ever see this? Question mark. Answer, she didn't never see it. I didn't never see it. And then it goes on to say, question, okay, all right. And did you talk to Ms. Cummings about that other than to learn that she had swept the floor the night before? Question mark. Answer, I did, she wanted somebody where her dad works to get a drug test to test it. Question, okay, and what did do you know what happened to it, this baggie? Yes, I told her, I said, just put it in my station and I'll get rid of it, and I threw it away. Question, so you told Jennifer that or Joleen? Answer, I told Joleen that. Question, how did Joleen take custody of the baggie? Answer, I don't know. She had it whenever I was off that day when it was found. And then she goes on to say, I threw it in the trash. That's from the owner of the salon. And then I also have text messages
I'm still having a hard time with what you've read to me thus far, where there's any evidence that's saying that the drug that was found, this bag of drugs that was found, was somehow Joleen Cummings, or
And
was
that,
linked to her by either the defendant or even the owners of the salon.
and then I have a text message from Joleen Cummings, which was provided to us, that talks about some hairstyles and the work that she and Ms. Kessler were doing. But the last sentence of that text message, and that is dated, I cannot read the date on it, I'm sorry, but it says, she is also telling clients about the bag of whatever on the floor in here.
She being who?
She's referring to Kessler. I'll read the entire set if you like, but I think, Judge, really that
No,
these.
I don't, I need the evidence, all right?
All right, well, I'll read here. Here is Joleen Cummings texting. She is just real smart mouthy towards everyone. It's been a week. I'm just trying to avoid her as she has been real negative in the books and numbers and saying, yeah, it was so, S-O-W, last year too, T-O-O. I don't know if she told you, but she's been working at John the Barber's a day or two. She doesn't want to market herself. I told her she could have all the flyers I had printed up from Vistaprint. She is expecting her book to fill up fast. She is a good stylist, but is getting a bad attitude. There is something little off about her. I can't put my finger on it. Her first color, I saved her butt, but she was going to put a straight 6RB on a lady with white new growth about 4 inches grown out, and the rest was a level 7 brown. This is referring to work in the hair salon that they cover for each other. And then Joleen goes on to say, I haven't said anything to her, but the clients are noticing. The other day, she would not rinse out Mrs. Edith for me, and I told her I would pay her. I had 3 of Crystal's clients at once. Mrs. Van Zant even said something about it. A client asked her to turn the air up the other day, and she said no, or nah, NAH, we're about to leave. And then the next paragraph on that text says, she is also telling clients about the bag of whatever on the floor in here. So that's the evidence that we would introduce regarding the issue of the drugs. And also Ann Morgan talks about that as well. Ann Morgan has told the detectives about the ongoing conflict between Kessler and Cummings.
Well, I understand, but does anyone say that it's because Joleen Cummings had drugs on her person in the salon?
I think that's the inference from this testimony. It's certainly an argument we can make if we're allowed to present the evidence to the jury.
Well, you're able to present the evidence that there was drugs in there. I'm just not seeing the link there that any of this. Go ahead.
Both detectives talked to Mrs. Simmons and Ann Morgan, and that Simmons and Morgan told both detectives that yes, there was a conflict about the drugs between Joleen and Kessler, that was the ongoing conflict, that Kessler was accusing Joleen of using drugs.
Okay. All right, I didn't read any of that in anything you read to me, in a text or in deposition testimony. That there was a dispute over there being drugs, and that there was concern by Defendant Kessler, and she was upset about it, but nothing that specifically relates to Joleen Cummings possessing drugs. Is there anything else out there, Ms. Thurston? I mean, that you're an officer of the court. I mean, is there anything else that relates or Joleen Cummings to having drugs inside the salon?
Not to my knowledge, Your
And the
Honor.
baggies that have been found, or baggies that had been found in the past,
Not aware of any baggies being found in the past.
or anything being found in the past?
No, sir. The only thing I know of is what defense counsel read from the text messages and from the deposition. Kessler found a baggie of something she believed to be drugs in this public business, Tangle's Hair Salon. She wanted to make a fuss about finding drugs in the salon and wanted to turn it over. She kept talking about it in front of the customers. Joleen didn't like it that she was talking about it in front of the customers and had actually offered to have it tested by her dad or her stepdad's business.
And all that's gonna come in.
Well, I don't know how that would come in. Joleen Cummings isn't going to testify to it. Kimberly Kessler remains to be seen, but I don't think she's going to be testifying to it. If Ann Morgan.
But it's not gonna be excluded, I mean, you're gonna, by the first motion in limit.
It has, my motion in limine, correct, my motion in limine was about Joleen Cummings being a drug user. It was not about this bag of who knows what, left by who knows who, found by the defendant and destroyed by the owner of Tangle Salon.
Okay. Not the one that was found in the tote bag?
My motion in limine didn't have anything other than the victim's character for drug usage. And that would mean something like we found drugs in her vehicle. What is the relevance of that? It is to prove bad character on the victim.
That Ms. Kessler and I guess Ms. Cummings were in over drugs being brought into the salon.
Again, defense counsel hasn't shown any dispute between the two of them other than Joleen is saying in a text message to her boss, Ms. Simmons, that the defendant keeps telling customers that she found drugs in the salon. That's what was presented as the evidence.
Well, there's more though, because the detectives took statements from Morgan and Simmons, who both reported that to the detectives.
Here's what I'm at, you're gonna have to proffer that testimony.
All right.
Because we're sitting here and I'm listening to it and I've not heard anything that links specifically any of the drugs that were found to Joleen Cummings. There's, I guess the defendant was upset that there were drugs that were found or purportedly found in the salon, and I guess that was something that she and Ms. Cummings may have gotten, at least from a defense standpoint, there may have been a dispute about, but there's nothing there that at this point that anybody can link Joleen Cummings with, the use of the drugs that were found in the salon. I just, finding some drugs in a tote bag in the car at this point, at this point, I don't believe that it has a lot of probative value. But I'm also having a hard time following the defense's argument, and I think I just need to hear the evidence, and I'll just take it under advisement. You can proffer it, and I'll make a decision in trial.
Do you want to proffer it before next week, or just should we do that next week?
No, let's go. We're going
All right.
to trial.
I'm just
take it outside of the presence of the jury, and I'll hear what you have to say.
because I'll need Miss Morgan and Miss Simmons and detectives Harrington.
I think
Okay.
you can probably do it without putting on the entire case. All right.
All right.
I think you can do that. So I think it's certainly, you can certainly talk about the dispute, that there was a dispute between the two, in the opening statement. And go from there. And I'm sorry, but I'm not. Anyways, I'm not following the argument. And candidly, factually, I feel like two people, it's like two people have run a red light at an intersection. Each says they've got believing in good faith that they've had the red light. It's just factually something that's in dispute as to what the evidence is, and so I'm gonna I'll take it under advisement and proffer it, and I'll give you a decision at that point, okay?
That's why I think it's important that the jury would make that finding. So I think that would be.
I still have to make the determination under 403 before the jury gets to hear it.
Certainly.
Okay?
All right, thank you, Your Honor.
Mr. Townsend?
I guess that just leaves, we have filed a notice of our intent to rely upon two summaries of the Stratton results. The court had a chance to see that.
Well, I saw the notice of summaries. I looked at them, but candidly, I really didn't know what they were summarizing. So,
Okay. Well, as the court may be aware, FDLE, FDLE reports themselves can be very hard to decipher.
yes.
We expect that Ms. Stratton obviously is going to testify. She's going to go through her reports. We
These
anticipate
are summaries of what, counsel?
of her reports.
Of report of what?
Of both blood, evidence that was collected
Okay.
throughout the case, Tangle's Hair Salon, evidence that was taken from Ms. Kessler's storage unit, and some items out of the vehicle. Quite a bit of biological evidence that was collected and was sent to FDLE for testing. Some either had nothing, had no blood or DNA on it, some was inconclusive, and much of it came back either positive for blood or DNA to either Ms. Cummings or Ms. Kessler. And so, and I have copies of the summaries if you'd like to see it, but I went
And
through,
they're attached to your motion.
we took her deposition and we sort of went through it just line by line to verify that they were accurate.
Is there an objection as to the notices?
There is, Your Honor. They filed this notice under, first of all, 90.956, which allows for summaries of voluminous writings, recordings, or photographs. The cases given under the Earhart's on evidence are cases involving things like bank records and those types of things that need to be, a forensic accounting has gone through and come up with a summary of what it is.
Right.
Your Honor, what they have presented is a chart from a report, that the report itself is not admissible, they just put it in their own writing. Ms. Stratton is going to come in here and she is going to testify as to what her FDLE DNA results are, as is the case in every case in this circuit and in this state. They testify to the results, that is the evidence. The chart that they have presented us with is merely, in the state's view, a chart for closing arguments, if they want to put it up something
A
like that.
demonstrative
A
aid.
demonstrative aid. It is not actually evidence, and it does not meet the requirements under the summaries because it is not the type of voluminous records, writings, and documents that is anticipated under statute 956.
Counsel,
Further, Your Honor,
go ahead.
I was not at the depot. I have been told from Ms. Thurston that they did not go through line by line, and I have personally gone through the charts, compared it to the reports, and the charts are not accurate.
Well, I'm not going to go line by line here today as to test their accuracy, but with a summary, okay, you can actually enter the summary into evidence with the the item, the actual original item. In this situation, though, what they're arguing, Mr. Townsend, is look, the report's not admissible evidence. It's not a business record or medical record or whatever. It's a report that's prepared for purposes of litigation or trial, and it just summarizes the testimony. So they're saying you can use it as a demonstrative aid with the caveat that it's accurate, okay, but not enter it into evidence itself, okay? Do you agree with that? Or would you like to tell me why their position is wrong in rebuttal?
Well, we felt it is a voluminous amount of testing that she did.
Yeah.
That being said,
But
I would certainly.
You can't come in and do a summary of someone's testimony on the stand and then enter it into evidence.
No, Judge, I would accept that, but I would ask that the state has some specific objection to this summary, that they would tell us what it is and we can sort of figure this out, so that we're not arguing about it during trial or at the end of trial. If we're gonna use it as demonstrative aid, that's fine, but I prefer not to be arguing about it then. So if she feels like there's something incorrect or wrong, or that she'd like to have corrected, I would rather that we address that now. And we certainly will just use it as a demonstrative aid.
And I would certainly appreciate that, because I do not want to waste the time of the jurors while we're sitting here hammering out whether, some one line out of 80 or
Right.
2 lines out of 80 are accurate or inaccurate.
Because I felt like we were very thorough in this, Stratton, and we certainly tried. If there's something we missed inadvertently, certainly we'll correct it, we'll fix it, but we prefer they tell us now and not wait till the end.
Okay, well, and at this point, as far as the notice of summary, I guess there's a motion somewhere in there with the notice. It's denied for entry into evidence, but defense counsel is free to use it as a demonstrative aid as long as it is accurate. Okay, and I would ask that the council meet and confer over that before the trial begins at some point, just to get that demonstrative piece of not evidence, but demonstrative aid.
Yes, thank you, Judge.
Correctly.
That just leaves I believe the curative instruction about Ms. Kessler's absence and the notice to take request to take judicial.
And Your Honor, as to the summary, I actually prepared and went through and wrote where it does not reflect the report for both of the charts, and I will provide this now.
So on the curative instruction, we both have submitted instructions, and the second part of the states is the second paragraph of the states is somewhat similar to what the defense provided. There's just the first paragraph. So what's the defense's position on all this?
Yeah, the second paragraph, I agree, is similar. I do prefer the way I wrote mine. So I guess I'll leave it up to the court to.
All right.
I mean, I'm requesting mine be read.
So you want to argue why yours is better than the state's?
Let's see. Yeah, I just think it flows better. I will say, when I drafted it, my thinking was for the jurors to know that as in right now during these proceedings, I consider it, then during deliberations, of course, and then refer to the verdict itself. So I that's why it has the different sentences in it.
All right. Does the state have a problem with the defense's requested instruction?
I do without the rule itself, which I had paraphrased. That's paragraph 1 is the rule itself. Their instruction starts with the obvious. She's absent from the proceedings. Where ours tracks the rule that it's either voluntarily absents herself from the presence of the court without leave of court, or is removed from the presence of the court because of her disruptive conduct, that the trial doesn't get postponed or delayed, but proceeds in all respects as if she were present in court at all times. And in fact, at least one of the jury instructions talks about to the jury, I think it's at closing, where, evidence that was presented in the presence of the defendant, the counsel, and the court. So I think it's important for them to not just state the obvious, she's not here, but that the rule provides for that she's absented herself or been removed, and that the trial shall proceed in all respects as though she were present in court at all times.
In response?
I object to the first paragraph.
Well, it accurately quotes the rule.
Right. This is the law or the rule to instruct the trial judge and personnel how to go through the proceedings. But the way this is worded, it's going to cause the jury to speculate. It says if she voluntarily absents herself or is removed, if it's disruptive conduct. I don't know why the jury needs to hear that. That's a decision for the trial court to make, to proceed with the trial, and then for the jury to be given a curative instruction. And the curative instruction I asked for is That was one I looked at, some cases I couldn't find. The Florida case, I have to go back and look. I think it was Connecticut and New York, but I found that language that I used. And in those cases, they did not go into like a rule of procedure. I don't think a jury needs to hear the rule of procedure.
Okay. I'm gonna, with respect to the instruction I'll read, I'm gonna read the defendant's instruction. I tend to agree. You know, it's an accurate statement of the law, but, you know, I'm a little uncomfortable reading that, and it's almost like, you know, the court's saying, hey, I'm gonna go forward on this no matter what. And, you know, we're just not speculate on any further or draw any inferences from it. And I think I'm a little uncomfortable reading that aspect of it. So I'll read the defense's proposed jury instruction on this, okay? All right, I think that's it from the defense. I guess, yeah, that's it for. Yeah, that's it. So now there's a state's motion, fourth motion in limine, a motion to strike your request to take judicial notice on the file out of Hillsborough County.
Judge, and I have a courtesy copy. We do have the entire certified files.
Okay,
I've got a courtesy copy for you.
all right. All right, so at this point in time, go ahead, let me hear from the state first, and then we'll hear from the defense.
Yes, sir. Since now the certified file has been provided, and as far as the court taking judicial notice, the court can take judicial notice, but there's still a question of whether it's relevant and admissible as evidence. So what the defense is seeking to do once again is create a defense for the defendant. The defendant.
That's what defense counsel does, isn't it?
Well, with consultation with their client.
All right.
So what, as far as factually, what we know is the defendant had a story that she told people at Tangles that she had a fearsome ex, that she didn't want anything to do with this ex. No name, no specifics. Then when she returned Detective Harrington's phone call, and Detective Harrington said, you know what, we're looking into your missing coworker, need to talk to you. Her response was, well, I can't be involved in a police investigation. I've got, and I'm not going to say she said the word crazy, but something along the lines of, I've got, a crazy ex. I don't want him to, a crazy ex, stalker, computer expert boyfriend that I don't want him to find me. So I'm not going to cooperate. So what it appears is that the defense is attempting to put in an injunction file that they found.
We've got a judgment and sentence here.
There is a judgment and sentence in there too, which does not show that he was convicted of a felony, but it does show that he was convicted of a battery, domestic violence, in 2010. So without any evidence or foundation from the defendant that this is the boyfriend she was talking about, the defense intends to put in, and I really should speak to him separately. So just as to the injunction itself, that she had filed a petition for injunction, which was granted. She had then filed I think there was also a allegation that he had violated it. Mr. Trombetta had violated the injunction by making a phone call to her. And then there was an final judgment of injunction. Yes, and then her allegation, and then it was extended. So we'll take both alternatives. The defendant doesn't testify, then these records are irrelevant. The defendant does testify and she says, I didn't want to cooperate with the police because I'm afraid of Mr. Trombetta finding out who I am. Well, long as she's not impeached in that, then they don't get to bolster her testimony by showing there really is an injunction against Mr. Trombetta. It is not relevant to the case as it stands. I don't think we're even going to, it's not relevant to the case. It is prejudicial, its prejudice outweighs any probative value. It certainly would be meant to confuse the jury. And should she testify and claim that this is the crazy ex-boyfriend stalker computer expert that she was referring to, then long as we are not impeaching her as to being fearful of Mr. Trombetta, then it would be just to bolster her testimony. As to Mr. Trombetta's misdemeanor conviction, it is completely irrelevant to this case.
Response?
Oh, I'm sorry. Sorry, it's so hard to hear with that fan underneath that low ceiling.
Well, the alternative is worse. It would be incredibly hot.
I know, or I could move to another place, because you can hear great in this central part with the high ceiling. So that's all right. I'm sorry. The state intends to introduce statements of our client made to 2 different detectives and possibly to Simmons and Morgan from the salon that says that she was hiding from an ex-boyfriend who had threatened her.
You're gonna enter that evidence.
Now, the state's gonna introduce that. They've already said that. And then they've said that they referred to that today as Ms. Kessler's story, which means they're referred to it as a lie. If they introduce that to the jury and intimate that it's a lie, we have ample evidence to establish that it's not. Ms. Kessler spoke to Detective Douglas for several minutes about this situation. There had been an injunction that was good for 25 years, which that 36. She was accurate about that. She told the detective she was afraid to get involved because she also told the detective that she was in the Attorney General's address concealment program for victims of domestic violence. That's what we've asked you to delay ruling on. So I think if you want more about that, we're going to find out about that at the evidence room in just a few minutes, I hope. But Ms. Kessler told Detective Douglas she was involved in this program. She was running she didn't want anybody to reveal her to Mr. Trombetta, that she was in fear of her life. And if the state tries to intimate that that's a made up story, then I think we can establish, even without Ms. Kessler's testimony, that there's a reason that she told all 4 people, Simmons, Morgan, Douglas, and Harrington, about this. So I don't believe that it's irrelevant, and I think it really, it's a rebuttal to the state's allegations that she was lying about this. Now, there's another problem, and that's if the state's intending to argue that Ms. Kessler made these statements but wouldn't talk about what happened to Joleen, then that's a whole separate issue. That's a Fifth Amendment issue. But hopefully, I mean, I'm not sure what the purpose is of introducing these statements, but the state, we filed a motion in limine and it was denied. So the state intends apparently to introduce Kessler's statements that she was on the run.
All right, I tend to agree with you as rebuttal to if there's evidence put in that she made these statements after her arrest or she was taken into custody. I think that does make this relevant, and that you do not need Ms. Seaver to testify to bring in, the judgment and sentence and the final injunction order. And all of this in here as far as the petition goes and all the statements that she made. I mean, that's hearsay within hearsay, and you can't put in your own client's statement. You can't put your own client's admissions into evidence. Okay?
I understand that. I'm happy with the judgments and
Well, and
sentences.
that's what it'll be. And so, but again, it's made relevant by what the state does with those statements after she was taken into custody. And so, but I agree with you on that. For purposes, I think it has probative value if those statements are presented to the jury in the manner in which they've been presented to the court, which is that they were, that she made these statements, they were spontaneous, and that they were not necessarily true. And so I think that.
The only reason we got the whole file is because the state objected to our partial
No,
file, so.
I think it's good they can see it and everything else, but the whole file's not coming in. But the judgment and sentence and the final judgment of injunction for protection against domestic violence.
And the extension order.
Judicial orders, yes.
Okay.
Statements by your client, no.
Can I ask how you handle that with the jury? Do you want us to give you the certified copies to read from, or
I
how?
would say you can announce we're presenting the certified copy, and you can, there'll be an objection or whatever, or I'll allow it, and then you can publish.
Yes, sir. All right.
Okay.
Thank you.
How you would with any document. All right.
Yes, sir. I'm sorry, and I know the court's had a long day too, so that I understand exactly what the court's rulings are. I know which documents you said
Yeah.
could come in rebuttal. If what?
If you put in evidence of statements made by Ms. Kessler after she was taken into custody about, and she was on the run because she was fearful. She had I guess there's one of the statements was she has had a ex-boyfriend that committed domestic violence towards her. I'm paraphrasing, but that's what I recall one of the statements. If that comes in, and then I think that for rebuttal purposes, they can bring in this evidence.
Okay, so, and I wrote down that you said after custody. So specifically as to the phone call that she initiated, made to the detective, she was not in custody, and she said, I'm not coming in because I have a crazy ex-boyfriend.
Okay, well no.
We're not talking about that statement.
No, I'm not limiting, I said after custody, I'm not limiting it. I mean, that statement, I'm sorry, I don't have an encyclopedic recall of when statements were made in relation to the investigation, but her statements to law enforcement, let's leave it like that. There's these statements that were made that come into evidence about her being fearful of a crazy ex-boyfriend. I'm using your terminology because she was a victim of domestic violence. Then the judgment and sentence and the orders in the domestic violence court file, I believe they're certified. They can come in. I think there's relevance to them at that point.
Yeah, there's no issue about whether it's post or pre-custody. It's just the statements. I mean, there are some pre-custody and some post-custody, but they're all in the same box.
It's the statement to law enforcement when there's an ongoing investigation related to Joleen Cummings. Okay, that's where the relevance from the state comes from, I think, and what they've been trying to argue, and I think that it's entitled to put these documents into evidence if that's what the state presents that evidence. Okay.
Thank you, Your Honor.
There's a fifth motion in limine.
Yes, and that would be the defense disclosed yesterday that they intend to use screenshotted text messages between the defendant and Vicky Simmons and between Vicky Simmons and Joleen Cummings.
All right, so can you tell me why they should be excluded?
Because they're hearsay and not under any exception.
And why should I admit that, counsel?
We anticipate Vicky Simmons will be testifying in court directly to these communications. We're not arguing the truth of the matter about what the substance is or isn't, but it goes to a state of mind that, again, this goes back to that original issue we were having. And I think there was some
Statement
confusion.
by Vicky Simmons about the defendant's state of mind.
Well, about the
Usually work that way. It's usually the defendant's statements.
defendant's state of mind and Ms. Cummings, that there was this ongoing, what Vicky Simmons, when she described it to Detective Douglas, she referred to it as an ongoing dispute that they'd been dealing with in the shop over this issue of the drugs that you've already addressed.
And that's fine, but. I mean,
It's just those narrow text messages that show the nature of the ongoing.
Well, but that is being offered to prove the truth of the matter asserted. Hey, these text messages show that we had an ongoing dispute. This is what the dispute was about. And see, here are these statements that were made out of custody.
Well, I can show you, it really goes to the state of mind of Ms. Simmons, because part of the
Why
time
is
she,
Ms. Simmons' state of mind relevant in this case?
it certainly shows her knowledge, Judge.
Who cares what, I mean, she can testify what her knowledge is, not bringing in an out-of-court statement. She's not the alleged victim, and she's not the defendant, so why do I care about her state of mind?
Again, going to how she obtained this knowledge. And part of this knowledge is coming to her through text messages she's receiving from both Kimberly Kessler
The
and
fact that
Joleen
it's-
Cummings.
That she received the text message from the defendant, not the fact that what the content of the text message. Is that what you're trying to say?
Just that, again, we're just trying to show the nature of this conflict. It is an ongoing conflict at this shop where there's 3 stylists. There's this ongoing conflict about drugs being found in the shop.
Okay, and we talked a lot about
Right.
that today, and we're gonna get into that.
Right.
But it's just whether this is competent evidence to prove that is the issue. And I'm still having a hard time with it being
Should we take
competent evidence, because it is hearsay, or at least it could. If it's not being offered to prove the truth of the matter asserted, I'm not seeing how you're doing that. That's all.
Okay.
Because Ms. Simmons is not the defendant. Of course, you couldn't offer your own client's statements into evidence anyways, certainly as admissions. Are you talking about, are those the text messages in question are the ones that Ms. Saab read to me, seems like hours ago now?
Yes, sir. Specifically, the ones that we were referencing were only the ones that addressed this issue of some mysterious substance being found in the shop. And then specifically Ms. Cummings talking about Ms. Kessler going on and on about it to the point, I think at some point they were having to tell her to stop talking about it in front of customers. So just expressing this frustration with Ms. Kessler continuing to talk about it even after it had been found.
I gotta be honest with you, I'm not seeing how these are admissible for the purposes that you're offering them. I think you're gonna have to proffer these when you get into that testimony, candidly. Okay, I mean, it's hard for me to make an assessment as to what they're being offered to prove here, kind of in a vacuum, so to speak.
I understand.
Okay, and I'm not, so you need to come sidebar, and you gotta just proffer them and I'll make a decision then.
And it may only become relevant if Ms. Simmons, for some reason, denies.
Well, that's a different story.
Right.
Prior inconsistent statement, and that's Yeah. as long
And all we did was listed in discovery, by the way. We just listed in discovery potentially, and I'll admit, it could, if she admits to everything, that probably they're, then.
Yeah, counsel's tendency in cases like, like this, and good counsel, which I'm dealing with the other day, and I'm appreciative of, is to try to think of every contingency and eventuality of the evidence, and it's just hard to, and I think this comes kind of under that heading, is we really got to see what comes out of trial.
Right.
So don't talk about them, don't present them as evidence, you become sidebar. And then we'll probably be in a better place to assess whether they aren't being often proved the truth of the matter asserted, or whether they're hearsay. Okay, so it's preliminarily granted, okay? Any motion in limine is always subject to proffer and consideration of trial.
And Your Honor, I would ask that if they intend to call Vicki Simmons, that before they call her to the stand, that this proffer be, because it's certainly not going to come out in the state's direct of Vicki Simmons. And if they think they're going to call Vicki Simmons just to testify to her knowledge, which is based solely on the hearsay text, that that she not even be called to the stand until the court issues a ruling.
Well, I mean, you agree that she can testify that about this ongoing dispute.
I do not. She doesn't have any personal knowledge of it. She didn't witness the ongoing dispute. She received the hearsay text messages and she threw away a baggie of unknown substances.
And had a phone call with Ann Morgan, so it was told, and so there's more to that.
That's more hearsay.
Well, it's one thing, it's one thing from Ann Morgan to rely on, I mean, that's probably hearsay, but if she's getting the text messages from the defendant about it and then acts on that, then.
Because she indicated she's the one that actually threw the drugs or whatever the substance was. She responded to it, she collected it, she threw it away.
Well,
So she
again,
is.
I'm gonna go back to this, okay? We're, good counsel is trying to plan for every eventuality. I get it, I appreciate it, and we're glad to try to hammer these things out early rather than on the fly, but I think that even what Ms. Thurston's trying to ask me to do, I think it's just not, I gotta see where things go, okay? I mean, if there are crosses beyond the scope of direct examination, then you gotta make the objection, and go from there. So
I'm sorry if I was confusing. What I asked is they not be allowed to call a witness for the sole purpose of this motion until the request for proffer is made. So we don't have a witness take the
That's
stand
fine.
and then
that's fine.
leave. Okay.
I mean, if you're saying that you don't even think she should be able to testify about the ongoing dispute because she's got. Okay, fine, we can, talk to that outside the jury. I'm not saying she's right or wrong, it's just, it's probably a better idea to do that, or, try to always establish it. Look, I can't sit here and micromanage this. It's just too, it's just, you guys will get in the trial and we'll hear it and see how it's offered. So I appreciate the effort trying to figure this out, but I don't see how. All right.
Judge, I think that was everything except, we were looking at the jury list, and did we ever address number 10? We had a
Is
question
that
about
the
him.
gentleman that was, possibly had a felony conviction
All right, I couldn't remember. I didn't.
out of state?
No, so that was.
The one guy I excused
Right.
that was local, we couldn't get the information that his civil rights had been restored, and when I looked at the charge, it was a second-degree felony trafficking, which I would.
I think that was number 36.
It's number 10.
You're talking about the individual that,
Oh, that's right. The out of state, that's right.
yeah. Did the state have a chance to
No,
look
sir.
that up?
No, sir.
No?
Oh, well, we got what our paralegal did as far as records.
Sorry, I moved the name because I'm not seeing it. Right. Start talking about searches.
I told them stop yesterday, I'm not coming for this yet, so.
According to the NCIC that was provided by the assistant, there does appear to be for juror number 10, a burglary conviction and a felony aiding or abetting conviction.
Okay,
They're listed on the NCIC. Everything else is that in the record that's a felony is to attempt to dismiss. But
felony has been dismissed,
yes, he's had other felonies.
other felonies,
This
but not the
person has-
ones,
Not the ones that I was talking about. There also appears
well, it
to
only
be
takes one, so.
an uttering. It looks like there are 3 adjudications according to the NCIC. There's no notation on the NCIC as to whether or
So
not-
what's the state's position factually on this? All right, Madam Court Reporter
I
is
did not get
irritated
it
with the
either.
two of us.
Yes, I did get it in the first statement. There's no notation on the NCIC.
NCIC as to whether or not rights were restored. That's not something listed on the NCIC.
The state's position would be, does the clerk have his date of birth?
We do.
You said we did.
As long as it matches up with the as long as it matches up with the NCIC, then we don't have any problem with him being
All
excused.
right, well, Ms. Bagley, you hold the key to resolving this issue.
Madam Clerk, do you want the date that I have?
Give it to me, I'll try to get it to you now. Take it from there, back to the original list. All of their work. So I'll take it to this to find the original list of stuff and all of their work, the one I have here.
The one that you have here does not match.
No, I did not, it's not list of data work, the list that we have here. I need to find the original list, since it's not working.
Well, we can recess and give you a moment, and then we can reach out by email and see if she's got the date of birth that you have now. We can reach out.
We have no objection to excusing a convicted felon. Did the court actually make a ruling on this motion for change of venue that?
I thought I was to keep it under advisement because I want to see if I can get a jury, and we still haven't completed that process, but I will say that I'm at least encouraged that we have 68. I'm sure that we'll lose 1 or 2 right away, just because a couple people said they could, you might lose someone as a felony and that sort of thing, but we're still in, I think we're in good shape, numbers wise. So, but I'm not going to rule on it until we finish the jury selection process.
Yes, sir. Thank you, Judge.
All right. Anything else? 8:15.
I'm sorry, Your Honor, I do have a question. One more. In anticipation of the defendant not being in the courtroom,
Yes.
we have a photograph of her. It's her arrest and booking photograph from St. Johns County. We had all markings that indicated that it was an arrest and booking photograph. We had that removed, and we were going to use that for witnesses to identify the defendant.
Okay. All right. There's a photo of the defendant.
That's fine. Well, we intend to introduce photographs of her at some point, so that was the statements.
All right, didn't sound like there's gonna be a problem.
Okay, so that will just stipulate that's the defendant, so that when witnesses identify the photograph, she's identified.
All right, well, if you wanna come up with a stipulation, you can. So I will read to the jury.
Thank you.
All right, so with that, I'm gonna end today's session and try to draft orders on all the motions that you all have presented this afternoon.